about the purported directive of the Supreme Court to suspend a decision of Parliament. We are not aware of any law or any constitutional provision that enables anybody to suspend a decision of the Speaker in Parliament properly constituted. What we know is that under Article 2 of the Constitution and Article 130 of the Constitution, the Supreme Court has jurisdiction to make a declaration as to whether or not an act is consistent or inconsistent with a provision of the Constitution. But to suspend a decision of Parliament or a directive of the Speaker in Parliament, we are not aware of the legal basis of a conduct like that. Be that as it may, we as parliamentarians act on the basis of communication coming to us from the Speaker. We don't hear things in the news and act on them, or cite copies of records of proceedings in any court on social media and act on them. We act on the basis of communication coming to us from the Right Honorable Speaker. And if that communication says we should walk into the sea, we walk into the sea. Because we listen only to the Speaker and nobody else in relation to the integrity, the legality, and the appropriateness of what has happened in the chamber of Parliament. So that is my brief response to you in terms of your question. And the second question, which relates to the precedent that has been set by Mike Okwe, and why we in the majority today will be seeking to benefit from that precedent. I will say that when Mike Okwe gave his ruling in 2020, there were many who disagreed with him, and there were many who benefited from that ruling. But when Speaker Bagwin responded to the statement made by our now majority leader, and went ahead pursuant to Order 18 to communicate the vacancy of the 4 seats. In responding, he made some comments also, and his commentary was so persuasive that even those of us who questioned the propriety of Mike Okwe's action in 2020 became convinced that indeed Mike Okwe was right. I'm one of those that in 2020 publicly disagreed with Mike Okwe. I believe it was because Mike Okwe did not articulate his position very well. And when Speaker Bagwin responded to the statement and communicated the vacancy of the seats, and in doing so made some statements, his arguments or his commentary in relation to Article 97 1G was very, very persuasive, very, very persuasive, especially his position that if Article 97 is applicable to the next Parliament, then it becomes a useless provision. It's not necessary. And those who provided for it in the Constitution could not have intended to engage in a useless exercise. So I can assure you that we are not convinced because Michael Quay did it. We are convinced because we now see wisdom in the provision in the Constitution and the action of those who drafted our Constitution.